Here is a message from our Division Director, Emily Bali.
Hello, I'm happy to have the opportunity to address you, our EBSD staff, who provide services to the most vulnerable in our community to ensure that their basic needs are met. In addition to ensuring those in need receive the benefits to which they are entitled, you also have the frontline responsibility to protect the integrity of the programs administered by EBSD. While the overwhelming majority of people comply with regulations in seeking services, there are occasional situations of fraud and abuse. This online training course on fraud prevention and detection is a requirement by CDSS and informs our efforts to ensure that our benefit programs are administered appropriately. Throughout this training, the principles of We Care are referenced, as maintaining program integrity is part of providing a great customer experience. I want to thank you all for the work you do each and every day to make a difference in the community.
The Human Services Department strengthens our community by protecting the vulnerable, promoting self-sufficiency, alleviating poverty, and improving the quality of life. We value excellent service, compassion, integrity, partnership, and effective practice. It is an unfortunate fact of life that some individuals occasionally need temporary public financial assistance. Citizens of the United States, through their elected representatives, have historically created and subsidized programs to assist the less fortunate and enable, when possible, the chance to become self-supportive. As a benefits representative employee, you have the front-line responsibility to protect the financial integrity of the programs which you oversee. Unfortunately, any program which disperses money and/or commodities of value is vulnerable of being abused. Public assistance programs are particularly inviting targets of abuse because of their nature and purpose in feeding, housing, and health maintenance of individuals and families. The Constitution of the United States is adamant on the individual's due process rights and the concept of innocent until proven guilty. This noble philosophy is translated into public assistance programs in the form of the following basic premise. In the absence of clear and convincing evidence of ineligibility, the applicant or recipient is always going to be deemed to be eligible. Another term for this concept is called presumptive eligibility. Thus, any questionable situation which cannot be resolved to a reasonable certainty indicating ineligibility will be decided in the customer's favor. This video will educate and remind you, the public assistance worker or benefits representative, about the active welfare fraud. Our goal is to give you, benefits representatives, and other support employees the skills which will enable you to be more proficient in the following areas. Know the laws and regulations pertaining to fraud and public assistance eligibility determinations. Be aware of the most common types of program abuse. Develop and improve your ability to recognize and resolve potential fraudulent or questionable circumstances. One of the documents utilized in the preparation of this video is the EAS Manual, or the Eligibility Assistance Standards Manual. Throughout the video presentation, you can click on the active links highlighted below to open any online resources available to you. The criminal act of welfare fraud is defined in the California Welfare and Institutions Code and restated in Division 20 of the Department of Social Services Operations, Policies, and Procedures Manual. In order for crime to occur, certain elements must exist. For welfare fraud to be established, Section 20.03.11 of the EAS Manual states a person must, knowingly and with intent to deceive or defraud, make a false statement or representation to obtain benefits, obtain a continuance or increase of benefits, or avoid a reduction of benefits. The second element in the statement, representation to obtain benefits, obtain a continuance or increase of benefits, or avoid a reduction of benefits, will be satisfied if the agency believes and is able to prove that the misrepresentation was done with the specific intent of deceiving the issuer of the benefits. This means that under no circumstances can a person unwittingly commit an act which constitutes welfare fraud. This statement bears repeating, as it is one of our key learning points. There can be no such thing as accidental welfare fraud. This is because there is no intent to deceive when a person makes an honest mistake. Program staff and supervisors are responsible for determining eligibility and the correct amount of benefits for all recipients. They must ensure that the applicant or recipient understands his or her responsibility for providing correct and complete data and for promptly reporting facts required for correct determinations of eligibility and the amount of benefits. Program staff must also ensure that the applicant or recipient understands the penalties involved for misstating or for not reporting relevant facts. This responsibility should be reviewed with the applicant or recipient regularly as a reminder or to clear up any misunderstandings. Program staff are also responsible for taking prompt action on information received and for relating information received or observed which may affect future eligibility or need, subject to the provisions of Division 22-000. When it is known that recipients have a problem in reporting changes, more frequent contact may minimize the problem when there is a reasonable doubt as to the continuing eligibility or correctness of benefits. This type of follow-up of information to prevent possible fraudulent action by the recipient is a recognized helping process for which program staff is responsible. Some customers may not be aware that they are committing fraud when they report inaccurate information. In keeping with our customer experience principles to ensure our customers are informed and empowered, the E from our We Care model, engage and clarify expectations, helps the customer understand their responsibilities while on public assistance. The E in We Care stands for engage and clarify expectations and includes 4 steps. Confirm personal information, determine or confirm the reason for their call and or visit, set meeting and conversation expectations, explain horizontal integration. This interaction will set the tone for the entire interview and is essential in communicating clearly with the customer. An example in setting conversation expectations is, in order for me to process your application, I am going to ask you a series of questions, including some about your financial situation and the composition of your household. These questions will help me determine what kind of assistance you may qualify for. How does that sound? Everybody makes mistakes. Our customers may forget to declare or report information which will impact their eligibility. These mistakes may cause an overpayment, which are collectible, but it is not a criminal act. These types of errors are called inadvertent household errors, or IHE. Lastly, an interesting element of welfare fraud is the requirement that the false statement must be material. This means that the untrue information must have an effect on eligibility. If a customer knowingly fails to report a fact, they have committed an act of perjury. But if the false statement doesn't cause an overpayment, there is no crime of welfare fraud according to the law. An example of this situation occurs when a vehicle is not reported for a non-Magi Medi-Cal case, but its value is below the threshold of property values. We will discuss perjury in more detail in a few moments. With program policies constantly changing, less verification is becoming required for approval. It is best to reference the desk aid on our EBSD intranet for guidance. Returning to the question, did my customer do this on purpose, knowingly, and with intent? The answer is found by examining the entirety of the circumstance. You, the benefits representative, will review several items in making your decision. When a person is accused of committing an act of welfare fraud, they also may be placed in jeopardy of being charged with other related criminal code violations. These items include: was the person advised of their rights and reporting responsibilities? Did the customer acknowledge understanding their rights and responsibilities? Is there any information to your knowledge which would make the department question the mental competency of the customer? Is there any circumstance, such as a possible agency error, which should have been considered in the IPV determination process? If the customer was advised of their rights and responsibilities and they satisfied their intake worker or continuing caseworker that they understood their reporting responsibilities, then the agency will presume that any false statement was made intentionally with the specific intent of deceiving the agency. The two most common offenses are perjury and conspiracy. Perjury occurs when a customer signs a document and swears that the information they have provided is true, when in fact they know the information is false. Almost every public assistance application requires the customer to sign their name, swearing under penalty of perjury that their answers are true and correct. Every public assistance agency utilizes affidavits or sworn statements which are signed under penalty and perjury. Because perjury is a felony, it is considered a serious crime. It is important that every intake and continuing benefits representative make it a part of their interviewing routine to define perjury for the customer and explain the potential legal liabilities of not being totally truthful. The other potential criminal act of committing welfare fraud is the act of conspiracy. Conspiracy occurs anytime two or more persons plan to commit a crime together. The crime does not have to be successfully completed. The acts of the persons involved just must prove that they intended to commit the crime. Relatives or friends of the customer can be prosecuted for conspiracy if they aided in misleading the agency. An example of conspiracy to commit welfare fraud can include, but are certainly not limited to, acts such as knowingly allowing your address or post office box to be used as a mail drop for a person who does not live there and is therefore ineligible to aid at that address. Just a reminder, remember to reference the desk guides to ensure what is acceptable verification, as we do not want to over-verify our customers. An alleged absent parent assisting a recipient in their deception of hiding his or her true presence in the home. These behaviors include sneaking in and out of the house, including hiding in their car a short distance from the recipient's home. Absent parents have also falsely claimed to be an unrelated roommate or used false identification. Any person who lies to protect a person known to be committing welfare fraud, either verbally or by providing a knowingly false document, is also subject to being charged with conspiracy. These actions can include creating false records such as rental agreements, fictitious residence verifications, and false pay records. People have even stolen blank paperwork from doctors' offices and created false pregnancy verifications. Please take note, while the benefits representative must notify the customer regarding perjury, there is no such requirement relating to conspiracy. The responsibility to not conspire to commit welfare fraud or any other crime is implicit in the behavior expected of all members of society. The individuals we serve in the Human Services Department are people who are at risk. We all have different intelligence levels, and some extremely good people just do not have the mental acuity to find and keep a self-supporting job. Some of our customers also have, or have had in the past, the problem of substance abuse, which includes alcohol. Certain legally used medications, sleep deprivation, and hunger can also affect a person's mental state. It is not unusual that a person will apply for a public assistance program, and after a few minutes of conversation, the benefits representative concludes that the person has a physical or mental disability, which may impact their understanding and ability to remember their rights and responsibilities. Mental competency is a necessary component in the determination of the knowingly aspect pertaining to the elements of the crime of welfare fraud and perjury. The critical learning point on this topic of competency is that a person must have the mental capacity to know right from wrong and the mental capacity to be able to understand all of their rights and responsibilities. The Department of Public Social Services has created alternative programs, such as the Authorized Representative Program, to remedy a customer's apparent mental shortcomings. If you, the benefits representative, have cause to question a customer's mental competency, you should notify your supervisor so that an appropriate decision can be made which will protect both the agency and the customer. This competency topic is specifically addressed in your EAS Manual, Section 20-006. As previously mentioned to you earlier, IPV means intentional program violation. Let's talk about them for a minute. An IPV means someone with the appropriate level of responsibility in your agency SIU unit has investigated the evidence regarding an overpayment and concluded that the person intentionally misstated their circumstances. This conclusion, however, only creates the potential for a final determination of an IPV. There are two common ways that an IHE is determined to be an IPV. The first is by having the alleged offender charged criminally and convicted. In addition to any criminal punishment and restitution, the offender will be sanctioned by the agency and their eligibility to benefits will be lost for a period of time. The second is to initiate an administrative disqualification hearing, or ADH. Choice number 2 is considered by the Department of Social Services as a reasonable alternative to criminal prosecution. The offender will still be reprimanded for their actions without receiving a criminal conviction, which could possibly disqualify them from obtaining employment in the future. Another option is to offer the accused person the opportunity to voluntarily disqualify themselves from the defrauded program for a specific period of time. This procedure is called a disqualification consent agreement, or a DCA, and it requires the approval of the district attorney and a judge. Currently, this option is not offered in Santa Cruz County. Administrative alternatives to criminal prosecution and their specific procedures are located in EES Manual 20-300. Everything you do as a caseworker has the potential to fall under future scrutiny and will be carefully critiqued by persons within our agency and the district attorney. Fraud is kept at a minimum by doing the best eligibility work possible. While these administrative decisions are not usually made at the caseworker level, we are mentioning them in this training because you, the benefits representative, are the person who is going to be providing much of the evidence which will be used in determining the appropriate disposition of a possible IPV. Almost every crime has what is called a statute of limitations. This simply means that a person may not be criminally prosecuted for fraud or perjury after a certain period of time has lapsed, which will be discussed in the next slide. The Constitution of the United States guarantees the right to a speedy trial. This protection was established because an unnecessary or unjustified delay in the investigation and adjudication of an alleged crime can hinder the investigator and the accused person in their efforts to locate witnesses and gather evidence. Furthermore, people's memories and perception of facts and events can be altered as time passes. The statute of limitations for welfare fraud is currently 4 years from the date of discovery of the offense for a felony and 1 year from the date of discovery of an offense for a misdemeanor, in association to Penal Code Section 803C. Since laws can change, your investigator can tell you what the current amount is to be considered a felony. If the benefits representative has sufficient evidence at the point of intake to suspect that fraud exists and it is overlooked or ignored, the statute of limitation has already begun. This is why it is very important for the benefits representative to clear up any and all inconsistencies, to ask the challenging questions, to ask those unpleasant questions, and to inform the customer that documents are signed under penalty and perjury. However, it is not the benefits representative's job to decide if the statute of limitation has expired. This knowledge will be obtained during the investigation, and the district attorney, SIU, or the judge will make this determination. What you, the benefits representative, need to remember is that a willful failure to address these questionable issues can also create the risk of any discovered overpayment being considered an agency error instead of an IHE or a possible IPV. The State Department of Social Services, our department's administration, the district attorney, and the courts all recognize how difficult and complex the job of a BR is. Protecting the integrity of programs while respecting the customer's right to a timely disposition is often a daunting and frustrating task. EAS Section 20-005 covers the agency's responsibility to operate in a timely manner. Other sections also dictate that aid must be determined within specified timeframes. Immediate need in the CalWORKS program is one of these mandates. EAS Manual Section 20-005.322 states that all circumstances pointing toward the possibility of fraud shall be referred for investigation within 5 days. Please note that this section does not say may be referred. It states shall be referred within 5 days. By far, the number one welfare fraud offense is unreported or underreported income. Most fraud cases are easy to prove because they are what are called paper cases. This term means that the proof is usually found in the form of documents, such as pay records. In the United States, there are 2 ways to be employed and receive money. You can either be self-employed or you work for someone else. Many public assistance recipients are persons who work for themselves, are often dependent upon a healthy economy. Some self-employment is also seasonal work. They also usually do their own bookkeeping. The other method of receiving money is by being an employee, and there are 2 separate types of employees. You can work off the books or under the table, which means that you are paid in cash and your income is only known between you and your employer. You can be on the books, meaning that you and your employer are reporting your work and income to the necessary government agencies. There are 2 primary methods of learning about possible unreported income. The first is the Always Welcome Citizen Informant. The second is called the Income and Eligibility Verification System, also known as EVES. This is discussed in your EAS Manual, Section 20-006. It is expected to have a working knowledge of the EVES program. As a quick summary, quarterly, all of the computers of relevant government agencies talk to each other and compare the Social Security numbers of public assistance recipients and their income reported by employers. For example, EVES has proven to be an excellent tool in protecting program integrity. When an individual works under the table, it makes it difficult to catch and obtain the necessary proof. In this situation, we have 2 lawbreakers to deal with, the employee or the recipient and the unethical employer. Under-the-table workers are usually discovered by citizen complaints. One of the biggest aids to all of law enforcement is the human nature that people like to talk and brag. When a person is putting one over, especially by cheating the government, they just have to tell someone. It is an ego rush. The Human Services Department does not worry about the motive behind individuals reporting someone for potential fraud. We focus on if the allegation is true. Every alleged misconduct must be pursued, but it must be done with the spirit of your customer being innocent until proven guilty by a preponderance of the evidence. Unfortunately, individuals will make false accusations against current recipients. These referrals will either be based upon malice or honest mistaken information. Some individuals with self-control can commit unreported income fraud for numerous years and never get caught. These people have discipline, keep a low profile, and are careful to prevent making a mistake. It is inevitable that sooner or later, each one of you will have a gut feeling that one of your customers is not being forthright with you. You can't prove it, but you just know there is something amiss. A good and traditional indicator of potential unreported income is the test of expenses exceeding their reported income. If a person's rent and reasonable household expenses are more than their combined grant and benefits, there is probably something going on that you don't know about. This situation does not always mean unreported income, but it is a condition which you, the benefit representative, need to recognize and discuss with your customer. This clarification interview falls under the category of helping your customer avoid legal trouble when possible. Remember, as long as you or another benefit representative at intake adequately gave your customer their rights and responsibility, you have done your job. Honesty is the responsibility of the customer. There is an old saying which states, "It is easier to be honest when you believe you are being watched." The best welfare fraud deterrent is still considered to be a vigilant and diligent benefits representative. A learning point for intake workers. A good habit to incorporate into your interviewing repertoire is to always tell an applicant that all money from any source must be reported. This following video will showcase the success of the working relationships of staff in the Special Investigations Unit. If it can be said that a good benefit representative partners with the applicant or recipient to ensure that the customer receives every benefit to which they are eligible, then the same description can be used to describe the relationship between the benefit representative and the investigations unit. They are partners. When an eligibility question arises or a doubt is raised about an individual's eligibility, the customer and the benefit representative will work together to resolve the issue. As an example of this, benefit representative and customer collaboration, the customer will sometimes be asked by the benefit representative to sign releases for third-party verifications. For example, verification of a rental agreement. The customer has two choices in responding to this request. They can comply, or they have the right to refuse to sign a release. However, if they refuse to comply with the benefits representative's request, their case will be automatically discontinued under the failure to cooperate in providing information rules and regulation. You cannot automatically infer any guilt or allege any wrongdoing based solely upon their willful noncompliance with any regulation. If this non-cooperation occurs at intake and no benefits have been issued, then the case will probably be closed as a denial or a customer withdrawal, and no further action is necessary. If the case is in a continuing status, however, the situation could be different. For example, during the annual redetermination period, the customer discloses new information regarding their living situation, such as a new rental agreement that requires third-party verification. If non-cooperation occurs, then there is maybe an overpayment which will need to be established, and the reason for which the overpayment needs to be determined. It could be an IHE, an admin error, or a possible IPV. You, the benefits representative, now have the dilemma. What can I do without the customer's or third party's cooperation? Here's your answer. Contact the SIU unit. Because of the confidentiality restrictions placed upon the BR by 10850 of the Welfare and Institution Code, this is where the benefit rep refers the case to SIU. The investigators assist the benefit representative to complete their tasks or cases. The fraud investigator has many functions, which include gathering evidence, preparing criminal cases for court or administrative hearings, and assisting the district attorney in securing a conviction. However, if you were to do a time study on your SIU personnel, you would find that most of their day is spent solving and responding to BR fraud referrals or assisting eligibility personnel in various ways. And what is the definition of a fraud referral, you ask? Most referrals are nothing more than a benefit rep requesting investigative assistance from the SIU. When a benefit rep reaches a dead end with the customer, the investigator will take over. He or she, not being part of the program side of the department, is not constrained by the 10850 Welfare and Institution Code and restrictions. The investigator can secure the necessary information for the benefit rep to make a fair and correct eligibility determination. These activities can include a personal visit to a non-responsive third party or to any person they deem it necessary to contact. Under certain legal situations, investigators can also request subpoenas and prepare search warrants, except in the case of a criminal or civil proceeding conduct in connection with administration of public social services. Generally, a fraud referral should more fairly be called an eligibility and verification request, because it is the next necessary step for the benefit rep in obtaining any information which may ultimately be used to determine the customer's correct eligibility and legal culpability for any discovered ineligibility and overpayment. In summary, it is important to remember that the benefit rep and SIU are partners, but never forget that the SIU is there to help the benefits representative only when it becomes necessary. Your SIU is not a substitute for thorough and professional eligibility work. Here are the 10850 WIC regulations as written. Subdivision A. Except as otherwise provided in this section, all applications and records concerning any individual made are kept by any public officer or agency in connection with the administration of any provision of this code relating to any form of public social services for which grant and aid are received by the state from the United States government shall be confidential and shall not be open to examination for any purpose not directly connected with the administration of that program or any investigation, prosecution, or criminal or civil proceeding conducted in connection with the administration of any such program. The disclosure of any information that identifies by name or address any applicant for or in receipt of these grant and aids to any committee or legislative body is prohibited, except as provided in Subdivision B, except in the case of a criminal or civil proceeding conducted in connection with the administration of public social services. The main learning point for this topic is Many times, the BR can resolve any questionable issues without bringing an investigator into the situation. We will take a short quiz to review what you have learned.